judges were on the same page with regards to one aspect. That is, the entire process of demonetization was undertaken by the central government with the best interests in heart and with the sole aim of handling multiple issues, including malpractices such as hoarding of black money, counterfeiting, terror funding, drug trafficking, emergence of a parallel economy, inflation, money laundering, amongst others. Having said this, Justice Nagarathna had differed with the majority on the aspect of legality of the process of demonetization. As per Justice Nagarathna, Section 26(2) of the RBI Act gave the power to RBI Central Board to demonetize banknotes and not to the central government. What she said was that the power that the central government has to demonetize notes does not come from Section 26(2), but it comes from Union List of List 1, Schedule 7 of the Indian Constitution, right? And to effect that Schedule 7 Union List, which talks about coins and currency, there should have been a legislation that came about pretty much in the same way as 1978 and 1946 demonetization measures, right? And that's where she differed. The second point where she differed was with regards to the reading of section 26(2). And what 26(2) says, and I quote: on recommendation of the central board, the central government may, by notification in the Gazette of India, declare that, with effect from such date as may be specified in the notification, any series of banknotes or any denomination shall cease to be a legal tender. So here, Justice Nagaratna's dissent differed on two aspects. One was whether central government has the authority or not, which, as I previously discussed, she says they don't have the authority under 26(2). The second point where she differed was whether the decision under 26(2) should come from the central government or the central board. In this case, she feels, as per the correspondence between the central government and the central board of the RBI, she feels that the decision should have come from the central board and central government could have implemented it. However, in this case, they did not get a recommendation from central board. Instead, they obtained a consent from central board, right? So in the she differed on the decision flowing, how it should have flown. And she feels that since it they obtained the decision from central board of RBI, that is not the correct reading of 26(2), and hence the notification under 26(2) and the subsequent ordinance and the subsequent act is all illegal. The other aspect that she differed on was whether all notes of the can be demonetized, or whether a certain series of notes can be demonetized. So as I previously said, the majority said that the entire denomination can be demonetized. Justice Ragarathna said that's not possible. You should have, when you say any series, you can only have series of a particular series of a particular denomination demonetized, right? And that was essentially her reading. Then she said that if the bank can demonetize the entire series, right, entire 500 or entire 1000 rupee notes, that would, in her opinion, tantamount to excessive delegation. So on a personal note, I am unable to agree with her view on two broad aspects. Firstly, if the government took the parliament route, as I had previously mentioned, the entire exercise of demonetization would be futile, because you would give people enough time to churn out the excess black money that they have. The idea behind passing a notification was to ensure minimal amount of to give minimal amount of time, so that people do not have the black money does not change so many hands, right? Secondly, if only a particular series of currency notes are demonetized, the purpose of demonetization again fails, right? You have to demonetize entire currency notes. You cannot say that, okay, 001 to 0010 500 notes are fine, but 0011 to 15 are not fine, and again 16 to 20 are fine. It cannot work that way. If you have too many 500 notes, or if you have too many 1000 notes that you feel are being hoarded, then the entire series should be demonetized. And that's how I am, and the majority also read the term any series in subsection in 2 of section 26 of the RBI Act.
Correct. Aishwarya ji, there's also the point that if any particular series only is being, demonetized, then wouldn't that also result in so much disparity in terms of who would even know where who has which part of which which notes of which series.
Correct. I mean, it
Wouldn't
will
that
be
also
very,
result in
exactly. It will
just
be very,
absolute chaos?
exactly. That's exactly what the majority also remarked, that you can't possibly have different series being demonetized, and that will also defeat the purpose. What are you achieving by doing that? So I think that really would have yielded a more cumbersome, chaotic situation where the bankers would have to constantly see the number of notes or the series of notes that are being demonetized. People would also, I mean, practically think about it. We would be going and checking each of our notes and seeing whether it falls in the series that has been demonetized or not. And you don't know whether what 500 note has gone to terror financing. If you know that a particular series is counterfeit, you can very easily say that this is the series that needs to go, but otherwise you can't.
Please remember to subscribe to us and switch on the notifications for this channel. For our other social media links, more content, and to support our work, please visit citti.net. Dhanyavad. Namaskar.